Welcome to our vibrant network of governance, risk, compliance, and cybersecurity leaders. We share cutting-edge insights, best practices, and innovative strategies to empower professionals in navigating the dynamic cyber threat landscape. Join Circolo de CISO to ignite resilience and data protection across industries.
Welcome back for the 6th edition on AI and intellectual property. And viewers, thank you for joining us. And if you have missed the previous episodes, please find time to go through our YouTube channel and look them up. And there's a lot of content in terms of how AI intersects with intellectual property. And today we are going to talk about ethical and social implications. So Thanuki, jumping straight into the question, how does intellectual property laws address ethical concerns?
Right. So why we're talking about ethics when it comes to intellectual property is basically because generative AI has the potential to create inappropriate, illegal content. There is possibility for misinformation, IP infringement, deepfakes, which take on the likeness, voice, appearance of people. Just yesterday, Scarlett Johansson has released a statement saying that her voice was used for this OpenAI agent, which she hadn't consented to. So there's a lot of conversation that's going on around even right now about this. So that is why we need to be talking about ethics and ethical considerations. So how intellectual property laws address this is, firstly, it promotes responsible innovation, right? How does that happen? Because in terms of putting something together, developers are encouraged to address certain ethical concerns like prioritizing fairness, transparency, and also mitigation of bias. Then you have this aspect of transparency requirements, which come to play at this point, which is essentially an ethical consideration. You need to disclose the workings of that invention, right? And that would help to identify and address any potential biases or historical inaccuracies or anything like that in terms of that invention. Again, when it comes to the patent examination process, right? Again, very strict disclosure requirements are there for AI inventions. These are scrutinized quite a bit, which also counters ethical considerations and ensure that the invention is a fair and transparent invention. And that essentially, when you look at what underlies all of this is that this essentially is encouraging ethical research and development practices as well when you put down requirements of this nature. And also there is a public interest consideration aspect when you talk about ethics, because the outcome, if that outcome is biased, if that outcome does not value the rights of the creator, or if that outcome cannot be equitably accessed by the greater society, then those are public interest considerations that need to be taken into account even within the intellectual property framework. And that is how I would say the intellectual property framework caters to specific ethical considerations in that way.
So you talked about public interest. So when we talk about public interest, how does intellectual property intersect with equitable access, right? Or how does intellectual property laws come into play?
Right. So intellectual property laws have everything to do with innovations and creations, which the end products are supposed to benefit the greater society and also, yes, the creators, the inventors themselves. So the first thing when it comes to equitable access, I would say, is that it incentivizes innovation, because if you have strong IP protections, that will motivate developers, researchers to invest in AI technologies and ensure that they can benefit from their innovations, right? And that increases the likelihood that various needs across different sectors and regions will be addressed when innovation is prioritized and incentivized through strong IP frameworks. Then there's also this aspect of technology transfer, which gets facilitated by intellectual property laws, because there's this aspect of licensing and sharing of technologies. So companies, research institutions can license their innovations to others to use them, including those in developing regions. So, like for example, that is where the benefit can come to countries like us, right? And that will foster, in that sense, it's fostering wider dissemination and access. Then also, it ensures fair competition. You need fair competition if you want to ensure that there's equitable access. If you are protecting even the smaller companies, the startups that are coming up with the new stuff against unauthorized use, IP laws can help to maintain a competitive market. And in that sense, it can bring a variety of these AI technologies to the market and enhance access, giving an equal playing field opportunity even for the smaller companies and not just the big tech firms, right? And also having a solid IP legal framework is very important, because that provides clarity. If there is absence of clarity in terms of the law, then all that we want in terms of creating equitable access and protection falls away. So that is another aspect that I would stress on. And finally, I would think that having a strong IP legal framework, like any other legal framework pertaining to any other specific aspect that we want to tackle, having a strong IP legal framework encourages investment, because having clear, enforceable IP rights attracts investment towards research and development. So, and in that kind of thing being facilitated, essentially the ripple effect is equitable access.
So that actually makes it very clear that it is important for us to understand the intellectual property rights or the property laws and ensure that all our innovations address that, so that we can have equitable access and also address the wider public interest. So Thanuki, thank you so much for sharing this thought. And viewers, please stay on and look out for our next edition, which will be on international perspectives and harmonization. Thank you, Thanuki.
You're welcome.